January 2022, Virginia expanded the scope of the Court of Appeals, which granted all civil litigants the right to appeal final judgments to the Court of Appeals. The General Assembly has also expanded the number of judges on the Court of Appeals from 11 as it was to 17, which means there are 6 brand new appellate judges on the Virginia Court of Appeals. So historically, civil cases could only petition to the Supreme Court, and they would only hear about 10% of the cases. So it was a very limited appeal right that previously existed. This change in the ruling allows all civil cases this ability to appeal. However, it's a pretty new process. These appellate judges are new to hearing these civil appeals, so there's not a lot of data on how they're going to rule. But we have a few ideas about what we could expect over time considering this broadened jurisdiction. So we can expect an increased number of appeals, especially on these civil matters. So expect to see a lot more of appeals. There's probably also going to be increased settlement leverage based on the threat of appeal, even after a trial verdict or a decision. Where previously cases, only 10% of cases would be heard, there wasn't a lot of teeth to that threat. But now with this new process, that could be used as leverage in the settlement negotiations. We also expect to have a broader development of case law, which will allow us to more effectively evaluate the trial risks based on precedent. So there should be a lot broader case law available on some of these key trial issues, which is a benefit to the expanding scope of the Court of Appeals.
Yeah, that last one is going to be a big deal down the road here in Virginia. I know in some of our larger cases where we're co-counseling or we have co-defendants with counsel from out of state, they're surprised that Virginia doesn't have many safety nets. And having an automatic right of appeal, which just changed this year, is a new safety net for litigants in Virginia that just didn't exist beforehand. Also, in terms of the written opinions, because what we're about to talk about with Supreme Court of Virginia, there's just not that many written opinions from the appellate level, and the circuit court judges prefer to do things by order and not written opinions. And so what you have is you have very little case law on especially evidentiary and other issues. And in fact, Virginia until recently didn't even have a codified rules of evidence. We had case law on it and we had, some horn book on it. But we were probably one of the last states in the country to actually put a rules of evidence together. And we don't exactly follow the federal rules because we have a little bit of a common law here we like to follow. And so we have a little unusual things with the rules of evidence. And we're hoping the Court of Appeals is going to give us hopefully stricter guidance on some of the things that we've been hoping for as defense attorneys in Virginia. So let's move on to the Supreme Court of Virginia. I put up there, as you can see, the petitions for appeal in civil cases from 2020. That's the last time we had statistical information on it. As you can see, 14% of petitions to be appealed were granted, which means they were granted in terms of they heard the case. Of those 14% that are granted, probably a little over half were actually reversed or modified from the trial court decision. Not a very large number. We really don't know yet how active the Supreme Court will be with reviewing the Court of Appeals in civil cases. I have some predictions. I've heard other people have some predictions. We'll have to wait and see. I haven't got there yet. It's really just too new. But my thought is, don't hold me to it. My thought is, at least early on, maybe for a couple of years, the Supreme Court may be more active to put its footprint in how the circuit courts and the Court of Appeals do business. And then it'll plateau over time to where the Supreme Court goes back to hearing very few, or maybe even fewer than 10% of petitions for appeal, because it's already gone from the trial level to an intermediate appeals level. One last thing on the screen, that's our Chief Justice in Virginia, Bernard Goodwin. He was a former trial judge in Chesapeake before that, and before my time, he was a partner at our firm.